Hello students, KTHM College, Department of Political Science. Myself, Chandanshive Vasudha, welcome you all for the subject Introduction to Constitution. So now we are going to start the next unit, that is Fundamental Rights, and in that we are going to see right to equality. So first of all we will see the subtopic of the chapter. So this is the second unit in fundamental rights. In that the subtopics are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, right to constitutional remedies. So we are going to learn this step by step. So as we are learning the fundamental rights, so we should know what is the meaning of fundamental rights. So fundamental rights are a set of rights that are recognized under the laws of a country to protect their citizens. In the simple words, we have seen the meaning. So the introduction of fundamental rights we will see in it has enriched in part third of the Constitution. From Article 12 to 35, it has written. The inspiration of the fundamental rights we have taken from the Constitution of USA, and our preamble is also is taken from the Constitution of USA, and it was the first country to start the preamble. Uh, Part third described as the Magna Carta of the India. Uh, After that, the fundamental rights in our constitution are more elaborate than those found in the constitution of any other country in the world, including the USA. After that, essential for the all-round development. Our fundamental rights is very essential for all-round development of the. Now we will see some features of our fundamental rights. So the first one is uh, the some of them means the fundamental rights. Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporation or companies. This is the first feature. Now the second one is they are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. After that, the third one is the fundamental rights. They can be suspended during the operation of national emergency, except the rights guaranteed by Article 20 and 21. Further, the six rights guaranteed by the Article 9 can be suspended only when emergency is declared on the grounds of war or external aggregations. So the either external emergency and not on the ground of the armed rebellions. So internal emergency. The suspension of fundamental rights during the national emergency is explained in the chapter 15. You'll see that. So the fourth one is they are justiciable, allowing persons to move the courts from their enforcement if and when they are violated. And the Last one is they are defendable and guaranteed by the Supreme Court. Hence, the aggrieved persons can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the high courts. So these are the some features of our fundamental rights. Now we will study our first fundamental rights, and very important, that is right to equality, which is mentioned from article 14 to 18. So in that, the first one is article 14, that is equality before law and equal protection of laws, this which is article 14. So this article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The provision confers right on the all persons, whether citizens or foreigners. Moreover, word person includes legal person, otherwise that is statutory corporators, company, registered societies, or any other type of legal person. So the concept of equality before law is of British origin, while the concept of equal protection of law has been taken from the American Constitution. The first concept is the absence of the special privilege in the favor of, of any person. The second one is the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts. And the third one is no person, whether rich or poor, high or low, or official or non-official, is above the law. This is the first concept. Now the second concept is the equality of treatment under the equal circumstances, both in the privilege conferred and liabilities imposed by the law. And the second is the similar application of the same law to the all persons who are similarly situated. And the third is the like should be treated alike without any discrimination. Thus, the former is a negative concept, while the later it is a positive concept. However, both of them aim at establishing equality of legal status, opportunity, and justice. The Supreme Court held that there were equals and unequals are treated differently, and Article 14 does not apply. While Article 14 forbids classes legislation, it permits reasonable classification of persons, objects, and transactions by the law. But the classification shall not be arbitrary on any intelligible, differential, and subsistential distinctions. So this is the Article 14. After that we will go further. So the prohibition of discrimination on grounds of religion, race, caste, gender, or place of birth, which is Article 15. So Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, gender, or place of birth. The two crucial words in this provision are discrimination and only. So the word discrimination means to make advisor distinctions with regard to or the distinction unfavorably from others. The use of the word only identify that discrimination on other ground is not prohibited. So the next provision of Article 15 says that no citizen No citizen shall be subject to any disability, liability, restrictions or conditions on grounds only of religion, race, caste, gender or place of birth with regards. So in that the first is access to shop, public restaurants, hotels and public places, entertainment, or the second is the use of wells, tanks, bathing ghats, roads and places of public resorts maintained wholly or partly by states fund or dedicated to the use of general publics. So these provisions prohibited the discrimination both by the state and private individuals. While the former provision prohibited discrimination only by the state. So there are some uh, mm, uh, three expectation to this journal rule by the non-discrimination. So um, so the first one is the state is permitted to make any special provisions for women and children, for example reservation of seats for women in local bodies or provisions for free education for the children. This is the first one. The second one is the state is permitted to make any special provisions for the advancement of an socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes, for example reservations of seats or free concession in public educational institute. And the third one is the state is empowered to make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribes regarding their admissions to educational institute, including private educational institute, whether aid and unaided by the state, except the minorities education institutions. So this is the article 50. After that there is article 16, which is equality of opportunity in matters of public employment. So this article this article is a further extension to meet the requirements of equality under article 14. According to this article, all the citizens should be given an equal opportunity in public employment without any kind of discrimination. However, concession extend to various groups by the state under this article no way constitutes discrimination to the general philosophy of equality among the citizen. At the same time, it has to be remembered this article is no way confers a right on citizen to prosecute a job on a guaranteed basis. So there should be no discrimination in the opportunity of employment or appointment. So again that the discrimination should be not on the basis of religion, race, caste, then place of birth or gender. So there are also six expectations in this article. So the first one is Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority as the public employment. uh, Act of 1957 expired in 1974. There is no such provision for any state except Andhra Pradesh. So the second one is the state can provide for reservations of appointments or posts in favor of any backward classes that is not adequately represented in the state service. And the third one is a law can provide the incumbent of an office related to religious and dominant denominational institute or a member of its governing body should belong to the particular religions or denominations. So this is Article 16. After that, the Article 17 is abolition of untouchability and prohibition of its practices. So this article abolish untouchability and forbids its practice in any form. This enforcement of an disability arises out of untouchability shall be an offence punishable in accordance with law. So, in 1976, the Untouchability Offences Act in 1955 has been comprehensively amended and renamed as the Prohibition of Civil Rights Act in 1955. So, it has been made, and the term untouchability has not been defined either in the Constitution or in the Act. So, there are some declaration in the act, so that is preventing any person from entering any place of public worship or from worshipping therein. After that, justifying untouchability or traditional religion, philosophical or on other grounds, denying access to any shop, hotel or place of public entertainment, insulting a person belonging to scheduled caste on the ground of untouchabilities, refusing to admit person in hospitals, educational institutes or hotels established for public benefits, preaching untouchability directly or indirectly, and refusing to sell goods or render services to any person. So this was in the act which was passed in 1955, which the name of the act is Protection of Civil Rights. After that, the last one is Article 18 of Right to Equality, which is abolish of title except military and academic. So, in Article 18, abolished titles and make four provisions in that regard. So, the first provision is it prohibits the state from conferring any title except military or academic title on anybody, whether a citizen or a foreigner. It prohibits a citizen of India from accepting any title from the foreign state. After that, the third one is a foreigner holding any office or profit or trust under the state cannot accept any title from any foreign state without the consent of the president. And the fourth and last one is no citizen or foreigner holding any office of profit or trust under the state is to accept any presents. So these are the four provisions which are made in Article 18. So it is clearly heredited that the titles of nobility like Maharaja, Raja Bahadur, Rai Bahadur, Rai Sahib, Diwan Bahadur, etc., which were conferred by the in the British rule, were banned by the Article 18, and as these are against the principle of equal status of all. So in 1966, the Supreme Court upheld the constitutional validities of the national awards such as Bharat Ratna, Padma Bhushan and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only prohibits the titles. Therefore, they are not violative of Article 18 as the theory of equality does not mandate the merit should not be recognized. So, if the title is given, it also ruled that they should not use as suffix and prefix to their names of their bodies. Otherwise, there should be the forehead awards. So this was stopped by the in the national awards were in institute 1954. So Morarji Desai was heading the Janata Party, and in 1976 it was stopped. But after that, it also again revived in 1980s by Indira Gandhi government. So this is all about the article 14 to 18, which is right to equality. Thank you all of you.